Hi, everybody. Welcome to our discussion on creditor-debtor relations and bankruptcy. That information is contained in Chapter 16 of your text. This is an important question because those of us who have been in business or run a business want to get paid. That's why we generally produce goods and services for consumption in the marketplace, is to realize an economic return on those endeavors. And so, understanding the ins and outs of getting money, particularly from folks who might be reluctant to pay it, is an important thing to understand in the world of business and the business environment. There are a number of different ways to ensure payment of services and goods and so forth that have been sold and performed in the workplace, and one of those are statutory liens. Now, statutory liens are those liens or encumbrances that are created through the statutory process. And as noted here, a lien is a claim against a debtor's property that must be satisfied before other creditors may claim the property or its proceeds to satisfy a debtor's obligation to them. So the most common form of a statutory lien is what's known as a mechanic's lien, and this is a lien that is placed upon real property to ensure payment for work performed and materials furnished in the repair or improvement of real property. So if you have a construction company come and add a sunroom to your house or put a garage on your premises, something of that nature, they have what is called a mechanic's lien, which means that unless you pay the money owed for doing that job, then they can execute that mechanic's lien and get money. Or if you try to sell the property before you receive proceeds, the proceeds to the extent needed to satisfy the lien will be paid to the lien holder. Now, there's a very technical and precise process by which one has to get a mechanic's lien perfected and put into place, and that really goes beyond the scope of our conversation, but be aware that they are there. There's also what are known as artisan's liens, and artisan's liens are liens on personal property to ensure payment for services performed to repair, improve, or enhance the value of the personal property. So think of car repairs and things of that nature. There are also what are known as judicial liens, and judicial liens are where a creditor goes into the court and gets a judge to sign an order ordering the debtor to provide certain funds to the creditor for monies owed. And excuse me, a little snuffy this morning, and these are some of the more common forms of judicial liens that are available out there. One is a writ of attachment, and in a writ of attachment, if a creditor is able to get a judgment against a person or an entity, and you are aware that that person or entity has certain property, the court can sign an order that would authorize basically the sheriff to come out and take custody of that property. Usually it's then sold and the proceeds are placed in the hands of the creditor. Sometimes you see, like, in construction cases, you'll see people go out and seize road graders and dump trucks and things of that nature. There's also what is known as a writ of execution, which is a court order following the issuance of a judicial lien to seize and sell the property of the debtor. So again, once a writ of attachment is in place, you can get a writ of execution, which means that property can then be sold. There's also what are known as garnishments, and garnishments we typically see in consumer debt sort of cases where a creditor, usually a hospital or a health club, a credit card company, has obtained a judgment against an individual, and then they get a court order which authorizes a third party to pay a portion of funds that they may have belonging to the debtor to that creditor. And so generally you think of like wages being garnished. So sometimes people get in a little bit of financial trouble and get sued, and to collect that judgment, a portion of their paycheck will get paid over to the creditor by the employer and that kind of thing. There are certain exemptions from that, again, because people people have to live and keep roofs over their heads and that sort of thing. And so the federal and state law both exempt certain portions of an individual's wages or salary from attachment, execution, or garnishment. So somebody doesn't have to worry about their entire paycheck or their entire set of assets being turned over to a creditor at once. Another kind of debt that we have are what are known as mortgages, and these are typically security for the payment of loans that are secured by real property. Anybody who's gone out and bought a house knows that unless you're paying cash for that, you've gone to your local bank or savings and loan and gotten a mortgage on that. And again, sometimes if you're borrowing money unrelated to real estate, if you're trying to secure a debt or something like that, oftentimes you might give a creditor a second mortgage in favor of that creditor to secure getting a loan. A couple of common forms of mortgages. There's fixed rate mortgages where for the course of 30 years you're going to pay 8%, and that you will have the same payment month after month, year after year. And then what became popular a number of years ago were the ARMs, or the adjustable rate mortgages. Those are situations where the mortgage rate in which the interest changes periodically. And of course we saw over time a number of years ago, I think back to 2008 and thereabouts, we saw a lot of people get into trouble with adjustable rate mortgages, where they would get a very low initial rate of 3% or something like that, and then the next thing they know, it balloons up to 12% or 15%, and they quickly found themselves underwater. And of course we saw that a lot of predatory lending dealing with the financial industry really caused that financial crisis back in 2008. I've got a telephone ringing, so I'm going to have to pause the recording for just a minute. So hang on just a second. I apologize for that. Okay, I'm back. I apologize for that. Let me get up and going again here. All right. In any event, we were talking about the fact that these adjustable rate mortgages, particularly those which were predatory in nature, really got a lot of people upside down, and was one of the precipitating factors to that financial crash that we had a number of years ago. Because the debtor-creditor relationship when it comes to mortgages can be for an extended period of time, in some cases decades. Creditors, again, are often concerned about coming up with ways to protect their interests in that. And again, the mortgage is obviously the best, because the property cannot be sold or disposed of if that mortgage has been properly executed and recorded and made of public record. But in some cases, we will see creditors require mortgage insurance. That's a typical part of many folks' monthly house payments. The mortgage should always be recorded in the appropriate office of the county of the recorder of deeds in the county where that property is, because that recording provides notice to the rest of the world that creditor does in fact have an interest in that property. And in some places, that you will see actually prepayment penalty clauses where people are are penalized for paying off their mortgage early. So again, anytime that you're getting ready to sign up for a debt that's going to take over 30 years to repay, make sure that you understand what the terms of that are. In the event that somebody has a mortgage securing a piece of real property, and the creditor is not being paid by the debtor, the way that interest is, or that money is paid is through the process known as foreclosure. And foreclosure is basically a legal process whereby the property is sold under the powers in the mortgage, and then the proceeds of that money or the proceeds of that sale are used to pay off the creditor, and then generally speaking, any funds that are left over would be distributed back to the debtor. And listed here are several ways that the debtor can attempt to avoid foreclosure if they find themselves in that position. And again, most of those involve trying to work out an arrangement with the creditor to perhaps have lower payments for a while, lower the interest rate, those kinds of things. All right. Debtors also have protections under our legal system, although increasingly we're seeing those statutory debtor protections sort of being eroded away in favor of laws that seem, anyway, to favor creditors. But debtors are provided in most every state what's called a homestead exemption, and generally homestead exemptions permit the debtor to retain the family home, either in its physicality or up to a certain value of the family home, as well as certain personal property free from claims of unsecured creditors and trustees in bankruptcy. Now, we're going to look at bankruptcy here in a little bit, but basically, these homestead exemptions, these personal property exemptions, if a creditor forces a debtor into bankruptcy, or a debtor, for whatever the reason, files for bankruptcy, they're not left destitute. In other words, we don't. If you file bankruptcy, you're not basically out on the street, sleeping on park benches. You are entitled to keep certain kinds of property, and we'll talk a little bit about that later. Additionally, in addition to keeping the home or value of the home out of bankruptcy, there's a certain value of household possessions that you're allowed to keep. There's a certain number of clothing items that you're able to keep. A vehicle, again, if you've got somebody in credit problems, you want them to be able to get back and forth to work to hopefully pay off those debts. Certain classified animals, livestock in some cases, pets, we don't want to have to, get rid of Fido if we run into financial problems. And then a certain value of business or trade equipment. Again, the idea being that, if you take a mechanic's tools away from him or her, how are they supposed to earn money to get above water again? All right. Well, let's talk about bankruptcy for a minute. Again, bankruptcy is one of those specialized areas of law that we could go on and on for lessons and lessons about, but we simply don't have the time. But bankruptcy in its most fundamental form is basically, as we used to always say, sort of an organized process by which the vultures are allowed to come and pick the flesh of the carcass. And while that sounds a little cruel, I guess. It does basically allow somebody who is in financial straits and the creditors to whom that individual or that company owes money to have an orderly distribution of that person's assets in order to get the creditors paid to some degree or another. One of the most common forms of bankruptcy is what's known as a liquidation bankruptcy, or oftentimes called a Chapter 7 bankruptcy. And in a Chapter 7 bankruptcy, basically all of the debtor's property is basically liquidated, and then the creditors are paid off. Usually there's not enough assets to pay off the liabilities. So again, depending on whether the creditor is secured or unsecured and so forth, the creditors many times will only get pennies on the dollar of what is owed. In the old days, 15, 20 years ago, or maybe a little more, bankruptcy was, I think, oftentimes abused, and you would see people sort of engaging in pretty reckless spending for whatever the reason, and then they knew that they would just simply file bankruptcy and have those debts discharged. In 2005, under the Bankruptcy Abuse Prevention and Consumer Protection Act, you always got to be aware of those words, Consumer Protection Acts, because they sometimes don't protect consumers very much. The protections under bankruptcy were severely curtailed, and sort of this idea of going out and living la vida loca and then writing all the debts off sort of disappeared. Now, that's not the only reason people take bankruptcy. Unfortunately, businesses fail. Life happens to people. You look at the number of bankruptcies that are filed because of medical reasons, that that people get sick and they simply can't afford their medical bills, and they have to take bankruptcy that way. There are a plethora of legitimate reasons to take bankruptcy as well. But liquidation is a pretty common form. And then there's what's known as Chapter 11 bankruptcies, which are reorganizations, where basically the debtor and the creditor form a plan by which the creditors will be repaid. The debtor, basically continues to function on as usual, and then once the plan is completed, the bankruptcy is over, and that person is free to go on again. In a liquidation bankruptcy, once it's over, the debtor is discharged from his or her debts, and basically starts with a clean slate. There's also what's known as a Chapter 13 bankruptcy, which is kind of an individual Chapter 11, where a debtor, again, 11s deal kind of with businesses, 13s deal with individuals. But again, the individual debtor and his creditors formulate a plan where the debtor will pay off, his secured debts. Those are debts like mortgages and things like that. And then as much as his or her unsecured debts as would be paid under Chapter 7, and then is discharged from the remainder of the debts at that point. There's what are known as voluntary bankruptcies, and voluntary bankruptcies is where somebody will actually go to the court and petition to be protected under the bankruptcy laws. And again, these may be folks who get upside down with their bills for whatever the reason, because of medical or sickness or lawsuits, that kind of thing. And generally, the voluntary petition or the voluntary process starts by the filing of a petition. And in that petition, the debtor and through his attorney, generally most cases, will list all the unsecured unsecured creditors and secured creditors that debtor has, where those folks are and how much is owed to each. Then there needs to be a listing of the debtor's assets, which includes their financial situation, property they might have, a current income and expense statement. Now, under bankruptcy law, debtors are required to attend pre-petition filing credit counseling. And again, this is to make sure that, bankruptcy is the way to go, to make sure that once bankruptcy is over, they're not going to find themselves in the same predicament again, and so forth. A copy of their federal income tax return to sort of verify some of the information that they've provided. And then under Chapter 7, they have what's called means testing. And under means testing, what we started to see is that, not just every Tom, Dick, and Harry can file bankruptcy and wipe out all their debts. There are certain financial tests that have to be utilized. And so if you can, under the means test, if a creditor can show basically that, we shouldn't just let this guy just liquidate all his debts to us, that this person or this company has the ability to keep working and paying us off a little bit at a time and we'll get more, they should be forced to do that. So that's sort of what the means test does. There's also situations of involuntary bankruptcy where basically, the person is just floundering or the company is just floundering, and the creditors can get together and file a bankruptcy petition against the debtor. These are not as common as voluntary petitions for bankruptcy, but you can see there that depending on the claim amount and the number of creditors, a person can actually be forced into bankruptcy court if they're not paying their bills. All right. Let's see what else we're going to talk about. One of the things that bankruptcy filing does is it creates what's called an automatic stay. So, many times, people who get upside down in their bills, are just constantly, fighting off, bill collectors, phone calls at all hours of the day and nights. Bill collectors can be pretty vicious folks sometimes. And so once and lawsuits are filed and, in this court or that court to collect this bill or that bill, and it just becomes sort of a mess for for the debtor. And so upon the filing of the bankruptcy petition, an automatic stay is obviously created. And what that automatic stay does is it automatically prevents the creditors from taking any additional action against the debtor or the debtor's property until the bankruptcy is received or is resolved. And so what that does is that sort of creates a bubble, I guess, around the debtor's assets, and then allows them to be distributed in an orderly fashion through the bankruptcy court. As noted here, if a creditor knowingly violates an automatic stay, then the debtor or others can potentially sue them for that. If it appears that the stay is really not necessary, that it's been filed, the bankruptcy has kind of been filed as a sham or something like that, it is possible, as you can see here, for the secured creditor to ask the court to lift the stay, at least as related to certain property or assets that creditor may have an interest in. Generally speaking, that automatic stay will terminate after 60 days after the secured creditor's motion, unless the court extends it. As you can see here, the stay does not apply to certain kinds of debts, such as child support, things or money that needs to be paid out of divorce, child custody, visitation, or domestic violence cases. And then again, if you are a frequent flyer in bankruptcy court, the stay may be shortened if you are a repeat filer. All right. Once the bankruptcy estate has been started, the petition has been filed, the schedules have been filed, the stay is in place, then certain property becomes the subject of the bankruptcy estate, which is handled by a trustee. And a trustee is a court-appointed individual who is in charge of sort of managing the bankruptcy. And so the bankruptcy estate will consist of current property held by the debtor, jointly held property that might be held that the debtor has an interest in. Maybe I own a piece of property with my mother. My interest might be subject to the bankruptcy estate. Property transferred by the debtor within 1 year prior to the filing of the petition. This used to happen all the time. Again, people would get upside down, and before they would file bankruptcy, they would basically give all of their valuable property away, and with the idea that once the bankruptcy is over, they would get it back from whoever they gave it to, and life would go on without any debts. And now the trustee is authorized to look back and recover property that's been transferred by the debtor within a year prior to the filing of the petition, and then proceeds and profits from the use or sale of the property of the estate. So if there's income producing property in the estate, that the income that's produced will be part of the estate, and then certain interests in property to which the debtor will become entitled within 180 days after the filing. So even if the debtor is entitled to receive some money or payments 6 months after the filing, those could be part of the bankruptcy estate as well. The debtor is entitled to certain exempt property, and we talked about that a minute ago. Again, they're able to keep a homestead, burial plot, or other real property. So again, keep the house up to a certain value. They're not going to take your cemetery plot away from you. Again, you can keep an interest in a motor vehicle, so you have a way to get to the doctor, get to work. Certain limited household goods, furnishings, apparel, and so forth. Tools of the trade. Certain life insurance contracts. Social Security, welfare benefits, alimony support payments, and certain pension benefits, prescription health aids. Hopefully they won't take your glasses or your hearing aids. If you've been injured and have personal injury awards coming to you, you're able to keep some of those. So again, once all the property is kind of collected and recovered by the trustee, then we look at paying that off to the creditors. And again, we look at both secured creditors and unsecured creditors. So a secured creditor would be somebody, for example, who has a mortgage interest in your property. An unsecured creditor would be your Visa card through your bank. Secured creditors are obviously the place to be, because if you're a secured creditor, you are generally going to be the first in line to get the money. After secured creditors are paid, then unsecured creditors get to basically divide up whatever's left, and oftentimes, if there is anything left, it's simply pennies on the dollar. The idea of going through the bankruptcy is that once the bankruptcy estate case is over, an order of discharge is issued by the court, and basically that order of discharge says, these debts are gone. Mastercard, you cannot sue this person on this debt anymore. He or she has been discharged, and so that's the goal is that basically we shake the etch a sketch and you start with a clean slate again. As noted, there are some non-dischargeable debts that exist, and those include back taxes. You're never going to get rid of Uncle Sam altogether. Child support, student loans, and any credit that you obtain within 90 days of the filing of the petition. So again, if it was your idea just to charge the heck out of your credit cards and then go on a vacation, and then file bankruptcy right when you get back, that may not be the best plan for you. Creditors do have a right to object to discharge if they think something's amiss. And as you can see here, a creditor could object to a discharge if the debtor has hid property or destroyed property or financial records with the idea of trying to defraud the creditor or the bankruptcy estate. If you can prove that, then that individual may not be allowed to discharge the debts to that creditor. If there have been previous discharges within 8 years of filing the present petition. Again, somebody cannot just consistently file bankruptcy year after year after year. There is that time delay. If you have not completed the mandatory credit counseling, that can be a reason to prevent discharge until that's done. And again, if you've been involved in proceedings that might result in a felony conviction in the case, that can result in discharge as well. In some cases, debtors do have a right to reaffirm a debt if they wish to keep the property. So if you have a car or a second car or something like that, and you want to keep that car, rather than discharging it, you can reaffirm that debt and say, no, I'm going to go ahead and pay for that, even though I could have it discharged. I want to keep that, so I'm going to reaffirm that debt. There's a bunch of rules about the ins and outs of reaffirmation, which sort of go beyond the scope of what we need to talk about, but do keep in mind that debtors have that ability to reaffirm debts if they want to. Okay, well, that was a really brief discussion of bankruptcy and creditors' rights, and again, remember, we do business to make money, not lose money, and these are methods by which creditors can hopefully protect themselves, and the ways that debtors can protect themselves as well. So we will visit with you in our next chapters, where we're going to be talking about business formation and forms of businesses. So we'll talk to you soon. Bye.